There are certain moments in a case where one piece of evidence changes everything. Lawyers on Reddit shared theirs, and you'd be surprised at what ends up being the detail that changes the entire case. Lawyers on Reddit, what was the best gotcha moment you ever experienced? So thinking of a gotcha moment that I had a case where the husband was claiming that he could no longer have a loving relationship with his wife because she had some injuries. And I ordered his medical records just to see, can he still make love or what other issues he may have. And in the medical records, I found he had an STD. And when I confronted him about it at a deposition, he freaked out. He actually tried to choke me.
Choke on your lies!
And it turned out that he was actually cheating on his wife. So his whole case got messed up after that, and he got caught in a lie. Lady got into a minor fender bender with a truck in a casino parking lot. She backed out of a spot into him. My guy said she parked and went inside the casino for a few hours. At her deposition, she testified that she was so hurt, she went right home and to a hospital. I asked if she was a frequent visitor of casino. She was happy to tell me she did, and she had a gold status, and showed me the card. I subpoenaed her rewards cards records, and it showed she was playing slots for hours after the accident. Oh man, this is why lawyers care about tiny details in depositions. The seemingly irrelevant question can be one that blows up the entire story. A good lawyer isn't just listening to what happened. They're listening for details that can be independently verified. In this case, asking about a casino rewards card probably seemed completely harmless. But the second she confirmed she had one, the lawyer realized there's probably a record proving exactly what she was doing after the accident. That's what makes this gotcha so perfect. She didn't have to prove she was lying through questioning. She just had to find the record that proved it for her. My client's house burned down from an explosion in the fuel oil tank used to heat the house. It was clearly the oil maintenance company's fault, but his homeowner's insurance, from a very reputable company, still refused to pay out, citing a ridiculous technicality in his policy. Essentially, the policy covered damage caused by the oil heater, but they claimed that it was the storage tank that exploded and wasn't part of what was covered. So they deny his claim, which was about $1.2 million, and then I get involved. During a deposition with the claims adjuster, I asked how she came to the conclusion that the storage tank was not a part, or at least connected to the heater. She states that she relied on her expert witness, who was an engineer. Little did she know I had already checked this person's background. He had zero engineering experience or education. What? As most of you might know, you don't get attorney's fees in most cases. However, when an insurance company denies your claim in bad faith, now you do. That's true. Her little admission cost the company about $500,000 in fees, on top of the original claim for $1.2 million. Oh man, that is a bad mistake. This is why one small admission in a deposition can completely change a case. The insurance company denied a $1.2 million claim by arguing that the explosion came from a storage tank that wasn't covered. So the lawyer asked a simple question: how did you come to that conclusion? The adjuster says they relied on their expert witness, an engineer. The problem? The lawyer checked his background. He had zero engineering experience or education. Now the question isn't just whether they denied the claim correctly. It's whether they had a legitimate basis to deny it at all. And that's what makes this gotcha so damaging. The lawyer didn't have to prove the adjuster screwed over his client. He just got her to explain exactly what the company relied on, and then checked to see if that justification actually held up. That little admission allegedly opened the door for a bad faith claim and roughly $500,000 in attorney's fees, on top of the $1.2 million in damages. Plaintiff alleged he was so injured in an auto accident that he couldn't work, do any regular activities, or pick up his young kids. He then posted on his public Facebook profile him doing the ice bucket challenge. If you're not familiar, he basically lifted a huge cooler filled with ice water over his head. His attorney had no idea he had posted it. Oh, this type of thing happens all the time. This is why lawyers tell their clients, do not post anything on social media. A lot of people get caught like this. In fact, most good lawyers do a background check on the person and check all of their social media to see if they're actually injured or just faking it. The plaintiff claimed his injuries were so severe he couldn't work, do normal activities, or even pick up his kids. Then he publicly posts himself doing the ice bucket challenge, lifting a huge cooler of ice water above his head. What was he thinking? The lawyer didn't have to prove he was exaggerating through questioning. The plaintiff created the evidence against his own claim and publicly posted it. That was the end of the case. This also reminds me of a case I once had, where this woman was claiming that she slipped down the stairs and she couldn't move her legs or do any normal activities. We searched her Facebook and found her in the middle of a human pyramid on the beach with two people on top of her. After we found that picture, we showed it to the insurance and the case was dropped. Had a client accused of leading the cops on a high-speed chase. Whoa. The cop on the stand estimated he was going 90 miles per hour, but never actually clocked him. Then the cop identified where the chase started with me and where it ended. It lasted about 2 miles. Then we went through his log of when it started and when it ended, about 3.5 minutes. Once you walk through the math on that, the average speed of this chase was 35 miles per hour. Client got acquitted real quickly after that. This is a perfect example of why specific details can be more important than what a witness estimates. The officer tells the jury this was a 90-mile-per-hour chase. But there's one problem. He never actually clocked the car with his radar. So instead of arguing with the officer about the estimate, the lawyer decided to get the important details. She had him confirm where the chase started, where it ended, and how long it took. About 2 miles in 3.5 minutes. Once you do the math, that's an average speed of about 35 miles per hour. And this is a classic lawyer trick. It's called boxing in the witness. You get them to admit certain facts, and then when you put those all together, they can end up hurting their case. Once the officer admitted where it started, when it ended, and how long it was, all the lawyer had to do was math. And once you do that math, it's about 35 miles per hour. The lawyer took the officer's own timeline and made his 90-mile-per-hour estimate much harder to believe. Represented a DUI client who swore up and down to me he hadn't been drinking or doing any drugs. Newbie officer who had his field training officer with him in the car. Rookie pulls client over for a tag violation. Walks back to the car with body camera still on. Training officer says, get him out for a DUI. And the rookie says, but he's not intoxicated. To which the reply was, do it anyway? Body cam clicks off. Turns on 7 minutes later and they're doing field sobriety exercises on my client. Client sat in custody for 3 weeks until I finally got the tape from the prosecutor and presented it to the judge. The poop looks from the prosecutor and FTO when the judge saw the tape. I'll treasure that one. Judge wrote the police chief a letter saying the FTO was dead to him and he denied every search warrant he tried to bring thereafter for being a liar. Client is hopefully still on track with his civil attorney in a lawsuit. This is the kind of body cam footage a defense lawyer dreams of finding, because normally you're trying to convince a judge that the officer's judgment was wrong. Here, one of those officers basically makes the argument for you. The rookie saying he's not intoxicated is huge, but saying do it anyway is what takes this to the next level. So here the defense didn't have to argue my client wasn't drunk. They had the police officer's own body cam footage showing that the officer investigating him didn't even think he was intoxicated. I was suing a landlord who failed to make serious repairs in order to force the tenant out. Oof. The hard part is proving bad intent instead of mere idiocy, so you get higher damages. Code enforcement was involved, so I requested those records. The landlord left a voicemail to the enforcement department saying to hold off on the fines. They will make the repairs as soon as the tenant is forced out. That was an easy case. This is basically a lawyer getting the perfect piece of evidence handed to them. The hard part of this case wasn't proving that the landlord refused to make repairs. It was actually proving why he refused. Because there's a huge difference between a landlord being negligent, like not knowing about the repairs or taking too long to get to them, versus a landlord intentionally withholding repairs to force a tenant out. The lawyer needed to prove intent, and the landlord basically recorded himself saying it. This is why you have to be careful with what you say that's recorded or what you send people via text or email. My brother is an attorney. He had a case where the guy said he was permanently disabled from a work accident. At a deposition, my brother overheard the guy talking about getting his house remodeled. He was already spending the money he thought he was getting. My brother drove by the house to see how much work was being done and saw the guy carrying bundles of roofing shingles up a ladder to the roof. Oh boy. This was before smartphones, so he drove to a Best Buy and bought a video camera. Went back and recorded the guy. He had copies made and sent to the other attorney. The guy dropped the suit and was back at work the following Monday. My brother's client didn't want to pay for the video camera. He saved them thousands of dollars. They eventually paid, but he still gets a little peeved when he talks about it. This is why you have to be incredibly careful about what you say during a deposition. The guy is claiming he's permanently disabled and can't work because of an accident. Then during the deposition, the lawyer overhears him casually talking about remodeling his house. Instead of brushing it off, the lawyer follows up on it and finds him carrying bundles of roofing shingles up a ladder. That's a smart lawyer. When something seems off, it's always good to investigate further. Sometimes lawyers will even hire private investigators to do this type of work. Now the comment here says, just out of curiosity, wouldn't the guy get charged for lying or whatever? There's no way you can go after a company for workers' comp or whatever and get caught in a lie, then go straight back to work, right? Or would the company have to press charges? So yes, he potentially could get in trouble. At a deposition, you swear to tell the truth. If he knowingly lied under oath, that could be a perjury charge. And if he intentionally lied to collect workers' comp benefits, that could be fraud. But getting caught doesn't automatically mean criminal charges. That's up to the state of whether they want to press charges. The lawsuit and criminal charges would be two separate things. Not a lawyer, but a legal videographer. This gentleman was claiming injury, seeking damages against his employer after a fall at work. He claimed he couldn't raise his right arm above his shoulder because of the fall. First deposition comes along, and I'm hired by defendant's attorney to videotape the deposition of the plaintiff. Anyone know the first thing a court reporter asks you to do in a deposition? Please raise your right hand and repeat after me. Plaintiff raises his right arm above his shoulder with ease and no sign of discomfort. Oh my gosh. Does not occur to him what he has just done. Both attorneys were looking down at their notes when this happened, and neither of them caught it. The plaintiff himself didn't catch it. The court reporter looked at him and then looked at me, and her eyes went wide with realization at what just happened. 4 hours of deposition proceed wherein the plaintiff is instructed multiple times to show his range of motion and proceeds to pretend like he can't raise his arm above his shoulder level, which he did at the very beginning of his deposition. Oh my gosh. Deposition ends. Plaintiff's counsel leaves. I call defense counsel, the hiring party, over and show him the first 2 minutes of tape. Counsel excitedly whispers to me, "Case closed. You just saved us tens of thousands of dollars. I got a $5,000 bonus and plaintiff's case was dismissed with prejudice." Wow. Oh my gosh. This might be one of the worst ways to accidentally expose your case. The craziest part? Both lawyers missed it. No one had to trick him or catch him outside of the court. He forgot about his injury and was all caught on videotape. Now, not every deposition you have to raise your hand like that, but you do have to swear to tell the truth. This guy made a very bad mistake. A $5,000 bonus? That might be the most profitable 2 minutes of footage he ever shot. I had a client whose $60,000 car was ruined by a shop that put in the wrong oil. We couldn't prove it at first. The engine blew up, oil leaked out, and evidence was lost. I subpoenaed their bank records, figured out they bought their oil from Costco, called Costco, and got their prices for the last 2 years. I then worked out the amounts they were spending, did some backhand math, and showed based on the values it was impossible they had ever bought the right oil. They settled in full immediately. This is really smart lawyering because the evidence he needed was already destroyed. So instead of getting them to admit what type of oil they used, he pulled the purchase records and worked backwards. Once he did the math, the shop simply hadn't bought in enough of the correct oil for their story to make sense. Costco probably didn't expect to become the star witness in this case. I was representing a mom in a bitter custody fight. Dad wanted full custody and argued mom was an unfit parent. Mom wanted full custody because dad had a history of domestic violence towards her and the kids. Dad's lawyer was doing a good job of painting her in a bad light during his cross-examination, and I was starting to get worried. His lawyer brought a close family friend as a character witness for dad, who said the usual nice things about dad. Then he said something about them owning chickens. I thought that was odd, so I asked more questions. I was able to get the friend to spill the beans that the dad owned chickens for illegal cockfighting, and he'd take his minor children to these cockfights. And when the children were acting up, he'd punish them by forcing them to feed the chickens, during which they would get pecked and scratched by the chickens. And obviously the children were terrified of those chickens. I could see the color draining from the dad's lawyer's face. Mom got full custody. Talk about your own witness completely backfiring on you. Dad's lawyer brings in a family friend specifically to prove that he's a good person. Then the mom's lawyer hears one random comment about chickens, follows up on it, and suddenly the witness is talking about how the dad uses chickens to punish and scare the kids. That's brutal. The witness that was supposed to prove why he should get custody ended up proving exactly why he shouldn't. I acted for a plumber who ripped up tile floor to replace a pipe. He installed new tile on top, but warned the owners not to walk on it for 48 hours. He emphasized not to let their kids or their dogs walk on it either. They walked on it, but alleged the defects were caused by improper install. We had an expert do a report which confirmed that it was consistent with proper installation, but people walking on it too soon. Crazy homeowners still went to trial on it. In their evidence disclosure, they included a series of pictures. One of the pictures had in the foreground a tile that was tilted upwards. The background very clearly showed a dog's paw pressing down on the other end of the tile. That wasn't so much an I got them situation as they got themselves. This is basically bringing your own evidence to prove yourself wrong. The homeowners claimed the plumber installed the tile incorrectly, even after warning them not to touch it for 48 hours. Then they submit their own photos as evidence, and sitting right there in the background, a dog's paw print pressed right into the tile. At that point, the plumber didn't have to prove anything. They submitted the photo as evidence that these people didn't follow the plumber's instructions. Imagine paying for a lawyer just to get cooked by your own dog's paw print. Never posted this before. Ex-wife trying to fight ex-husband's new girlfriend. New girlfriend is in her car trying to flee while ex is beating on car, blocking escape and grabbing at door handles to get in, but doors are locked. After ex briefly moved out from the path of the car, new girlfriend begins to drive away slowly. Ex, noticing the car starting to leave, dives onto the hood of the car, slides off, gets run over at slow speed and breaks bones. Several surgeries later, ex sues the new girlfriend, alleging negligence in hitting ex with the car. Oh boy. As I'm deposing ex, she claims to have never touched the car before it hit her, never punched or kicked the car, never broke the windshield wipers, never grabbed the door handle to try to open the door, never dove on the hood, just yelling. I asked what new girlfriend was doing during this time, and ex describes new girlfriend as a deer in headlights, staring straight ahead, locked in her car, both hands on the steering wheel. How did you know the doors were locked? That one got dismissed pretty quickly. That's hilarious. Oh, that's a brutal question to get caught on. She's adamant that she never touched the car, but somehow knows that the doors were locked? How did you know the doors were locked? That's the kind of question where you can almost hear the entire case go silent. She didn't get caught by some crazy evidence. She got caught because she knew something she shouldn't have. You know her lawyer was staring at the floor after this one. Plaintiff had an x-ray of an allegedly broken arm. It seemed off to me, and the dates didn't make sense. I was in-house at an academic medical center. I looked at the case more closely and discovered the plaintiff was an x-ray tech at another hospital. After that, it was all over. So when the lawyer here says that they were in-house at a medical center, it means that they have a lot of knowledge about medical records because they work with those types of cases all the time. This one is crazy because the dates are what gave it away. The plaintiffs submit an x-ray about a supposedly broken arm, but something about the timeline doesn't add up. The lawyer looks deeper and discovers that the plaintiff worked as an x-ray tech at a different hospital. At that point, you know this person has access to other medical records and x-rays. And you start wondering, what x-ray am I really looking at? Sometimes you don't need a massive contradiction. You just need one thing that doesn't make sense and an instinct to keep digging. And now let's look at the comment. Ooh, poop. Does HIPAA apply here? Even if it's not identifiable, name erase, it's still someone else's medical info. Yes, HIPAA could still potentially apply. Removing the patient's name alone does not automatically make the x-ray HIPAA compliant or okay to legally use. Just so you know, HIPAA is a federal law that protects the privacy of patients' health information. And this x-ray tech was using someone else's medical records. Knowingly submitting someone else's x-ray could also create issues of perjury or fraud, and you may even get sanctioned by the court. And HIPAA has specific requirements for when health information is properly de-identified. This plaintiff could get in a lot of trouble, on top of lying in their case. If you enjoyed watching this video, click here to watch another one.